Good evening to the audience who has tuned in. I would like to thank WIPF for organizing the second season of virtual conference and inviting us for addressing a session in this conference. I hope everyone is doing well in these tough times. I welcome all of you to our session divided in divisional by LS Dower team. We are representing LS Dower and Company, which is the oldest intellectual property law firm in India of Indian origin. We serve our clients globally in preparing, filing, drafting, and enforcing intellectual property rights related to patents, design, trademark, and copyrights. We also serve our clients on the matters related to IP transactions and IP contracts. So this was about our firm. Now I would begin with our introductions. Myself, Astha Sharma, who is a patent attorney and serving clients in the field of life sciences and chemical domain. I provide end-to-end services and legal opinion on their inventions. So this was about me. I would like Mr. Mishra to introduce himself to the audience.
Thank you, Astha, and good evening, everyone. So I'm Sonal Mishra. I'm looking after the litigation department at Ellis Tower and Company. I also advise clients on their prosecution strategies before the Indian Patent Office. That is about me. Thank you.
Thank you, Mr. Mishra, for introducing yourself. I would like Mr. Bansal to introduce himself to the audience.
Good evening, everyone. I am Chirag Bansal, working in the capacity of patent attorney with Ellis Tower and Company. I handle prosecution and contentious matters related to software and electronics domain. Well, that's about me.
Thank you, Mr. Bansal, for introducing yourself. I would move forward to Mr. Aryan. I would request him to introduce himself to the audience now.
Thank you, Astha. Good evening to all audience. I am Manish Aryan, Senior Patent Attorney at LS Dower and Company. My area of practice includes patent prosecution and litigation. I regularly appear before various patent offices and IPAB. I mainly deal in ICT domain, automobile, etc. And I thank WIPF for organizing this virtual conference.
Thank you, Mr. Aryan, for introducing yourself. Now we shall move forward to our session divided by division. So I would like Mr. Mishra to enlighten us with his opinion on the divisional applications.
Thank you, Astha. So before we begin, can you just brief our audiences or apprise the audiences on the salient features of a divisional application? What are the main features of a divisional application before we deep dive into the topic?
Sure, Mr. Mishra. So I would like to talk about on divisional application. I would provide you an overview on the divisional application. As the name suggests, divisional. So this is an application which is divided out of a parent application or the first mentioned application. In this application, the crucial point to remember is the specification should not contain anything which was not already present in the parent application. Claims instead should contain distinct invention of that parent application. So divisional application in short is an application which has a claim of a parent application belonging to a distinct invention. Now, divisional application also follows the provision which the parent application follows. We need to file request for examination for divisional application as well. The timeline for doing the same is within 48 months from the filing date of the application or the priority date of the earliest, or within 6 months from the filing date of the divisional application, whichever is later. Divisional application can be filed under two conditions. One, if the parent application is objected by the controller having multiple inventions or distinct inventions. In that case, an applicant can go ahead and file divisional application with the group having a distinct inventions. The other opportunity provides by the Indian Patent Act is a suo motu filing of divisional application. However, in the latter case, the onus of proving that the parent application relates to a distinct invention lies with the applicant. Applicant has to prove how the parent application belongs to the distinct invention. Now, the parent application should be filed before getting any decision from the controller, be it a refusal or the grant of application, or if the applicant decide to abandon the application or withdraw the application, the divisional application should be filed before such actions. The term of a divisional application is 20 years from the date of filing of the parent application. One of the important things to note while filing a divisional application that it should include a cross-reference to the parent application while filing a divisional application. So this was on the overview of the divisional application. And now I would request Mr. Mishra to deep dive in this topic and apprise our audience on divisional applications in India.
Thank you, Asta. That does set the tone for the discussions. So, to put things into perspective, if we closely look at the title, it will suggest that the practice related to divisional application in India is not in complete consonance with the provisions in the Act, as well as the judicial rulings. And when I say judicial rulings, particularly by the Intellectual Property Appellate Board, and that's why the subject requires discussion as much as it requires a clarity. So what are the conditions? What are the mandatory conditions upon satisfaction of which a divisional application may be filed? So the foremost important condition is if it is successfully established that the proposed divided claims fail to establish a single inventive concept. And therefore, there is existence of multiplicity of inventions in the parent application, which is why we are filing a divisional application based on one of those inventions or on all of those inventions which are claimed or disclosed in the specification of the parent, but because it is directed to a different inventive concept, has to be claimed or may be claimed in a separate divisional application. Now, another requirement is the proposed divided claims are already part of the specification of the parent application, or it is already part of the filed claims of the parent application. Now, this second requirement again does a justification to the title. Why? The law and practice in this regard seem to be inconsistent, which we shall touch upon in the course of our discussion. So because of this second requirement, again, the practice is divided when it comes to divisional applications, which we'll know in the course of the discussions. So again, before we examine these issues, I'll take a small diversion. So in our experience, our foreign clients equate divisional application with a continuation application at the USPTO. So what is the difference between a divisional application and a continuation application? So in simple terms, a continuation application is a new patent application allowing one to pursue additional claims based on the same description and priority date as a pending parent application. I'll repeat the definition for you because this is important to understand how it is similar or different from a divisional application. So a continuation application is a new patent application allowing one to pursue additional claims based on the same description and priority date as a pending parent application. So it does not restrict the claims to the already filed claims of the parent application, rather it talks about the description. So prima facie, this appears to be similar to a divisional application in India, because divisional application is also filed when there is a multiplicity of claims or multiplicity of inventions disclosed in the specification of the parent application. Based on that, a divisional application can be filed. However, while both the continuation and divisional may be filed when the parent application covers multiple inventions and the applicant is either directed by the patent office or wishes to pursue other inventions suo moto in a continuation application or divisional. However, again, unlike continuation application, a divisional application may not be allowed if the applicant wishes to pursue broader claims in the divisional, which may not be allowed by the Indian Patent Office. Another thing is, with divisional, we may not be able to cover claims covering future advances. We may not also be able to file a divisional with claims covering a competitor's product, even if it is described in the parent application. So there are certain limitations with respect to divisional application. Now, therefore, a divisional application may not be used as an options contract to pursue new additional claims for any reason in future. We know what is an options contract in the contract law, where options contract includes certain clauses which may be used in the future, which may be exercised in the future. So a divisional application may not be used as an options contract, which is the case with a continuation application. So again, continuation application appears to have a broader scope than a divisional application, which sort of limits the use of divisional as a strategic tool. But in view of the divided practice related to divisional at the Indian Patent Office, it may on occasion serve as an effective tool to further numerous business objectives of the applicant as in continuation application, which we'll discuss in the course of our discussions today. So I'd also want to make a point that the chances that a divisional application may just serve the purpose of a continuation application cannot definitely be ruled out, but generally it will serve a limited set of purposes as discussed. So going by the practice, going by the act, it may serve as a limited purpose, but certainly if you use it as a strategic tool, if you understand that there's a practice at the patent office which is different, which is distributed, which is divided, certainly this can be used as a strategic tool. So this brings me to another question. So can a divisional application with similar set of features as claimed in the parent application be allowed? Why is this question important? Because there could be instances where an applicant wants to file a set of claims in the divisional application which is derived from the already claimed set of claims in the parent application, or set of claims or set of features which are disclosed in the specification. So what could happen sometimes is that there could be an overlap between the features you have claimed in the parent and which you propose or want to pursue in the divisional claims. So I'll explain this through a case where two divisional applications divided out of same parent application which was granted was refused by the patent office. So the parent application was granted, but the divisional applications, those two divisional applications were refused by the patent office. So the applications were then transferred to us. So the divisional applications were prosecuted by another firm, which was then transferred to us, and then we filed a review petition for those two divisional applications. Now the applications disclose inventions from the field of signal processing. So it is to be noted here that all the three applications, the parent and two divisional applications, were filed with identical titles. So the title were same in all the applications. That is why I said that if the title was same, the chances were very higher that most of the features could be overlapping between the claims of the parent applications and the claims which are divided out from the specification or the claims of the parent application. So there could be an overlap between the features. So the controller at the patent office refused the two divisional applications by stating that the claims of the parent application do not have multiple inventions. And since the claims are similar in scope, it was already granted in divisional, and so a double patenting cannot be allowed. So this was the contention of the controller while refusing the divisional applications. The controller also compared Section 16(1) and Section 59 of the Patent Act and maintained that a divisional application cannot be filed for any matter disclosed in the specification, but when only there are multiple inventions, and further those multiple inventions should be claimed in the specification of the parent application. So this was again the reasons given by the patent office in this particular order. So now this was also ruled in the recent order in ESCO Corporation versus the Controller of Patents and Designs later last year around October 2020. And in this case, the Intellectual Property Appellate Board, or the IPAB, ruled that the filing of a divisional application arising out of a parent application is allowable, provided that the claims of the divisional application finds its roots in the claims of the divisional claims of the parent application. So this order suggests that if your proposed claims of the divisional is not already part of the claims of the parent, you may not be allowed to file the divisional even if it discloses the multiplicity of inventions. And that is what we believe that this is a flawed order, or this order is bad in law, and someday it will be overturned. And that is why, again, it brings us to the title of the discussion, that there is a practice which is divided because of the interpretation of the relevant section. So now coming back to the case in hand, the patent office in the refusal order also seemed to wrongly interpret section 59 of the act by stating that what is not claimed is disclaimed. That is, you cannot bring any matter from the specification in the divisional claims. So again, we believe that this interpretation of the section is flawed. So before we get into the arguments, we put forth in our review petition, I'll take a quick diversion and quickly look at section 16(1) and section 59 of the Patent Act, since it's important in the light of the ESCO Corporation order. So section 16 is with respect to divisional applications, and 16(1) particularly states that a person who has made an application for a patent under this act may at any time before the grant of the patent, if he so desires, that is voluntarily, or with a view to remedy the objection raised by the controller in the examination report or the office action on the ground that the claims of the complete specification relate to more than one invention, file a further application in respect of an invention disclosed in the provisional or complete specification already filed in respect of the first mentioned application. So there are two parts of this section. The first part suggests that the claims of the complete specification relate to more than one invention, which has prompted the IPAB and few of the examiners at the patent office to only allow the claims of the divisional application based on the claims of the ordinarily filed claims, which are directed to a different invention. But if you look at the other part of the section, it suggests that it should be the further application in respect of an invention disclosed in the complete specification. So if you give a purposive interpretation to this particular section, a division application must be allowed if there are multiplicity of inventions disclosed in the specification and not only claimed in the parent application. So this is the reason why we say that opinion of the IPAB and different examiners of the patent office on divisional application is divided. So if we closely look at this section, you would appreciate that it leaves a scope for interpretation. So some interpret it in a different way. Some controllers or the IPAB gives it a strict interpretation, and some gives it a interpretation. So that is the reason the practice is divided when it comes to divisions. So now it is also pertinent to look at section 59, because the controller in this particular case has also cited section 59 as a reason to disallow the divisional applications. So section 59, particularly section 59(1), which states that no amendment of an application for a patent or a complete specification or any document related thereto shall be made except by way of a disclaimer, correction, or explanation. And no amendment thereof shall be allowed except for the purpose of incorporation of actual fact. And no amendment of a complete specification shall be allowed, the effect of which would be that the specification as amended would claim or describe matter not in substance disclosed or showed in the specification before the amendment, or that any claim of the specification as amendment would not fall wholly within the scope of a claim of the specification before the amendment. So the section is pretty clear in its interpretation. And combining it with section 59 would again suggest that we want to apply section 59 to section 16, it would be only in cases where the divisional application is being amended, and not in when the divisional application is filed based on the matter disclosed in the specification of the parent application. So this section would only find relevance if at a later stage divisional application is being amended and not prior to that. So again, we believe that this was a wrong interpretation from the patent office. So section 59 is clear that it allows the specification to be amended, as I said, and it allows the claims to be amended. It allows for voluntary amendment of claims also, which brings matter from the specification to the claims, given the new matter brought to the claims is well supported throughout the specification. And therefore, if we give a purposive interpretation to section 16(1) and section 59, divisional application filed voluntarily must be allowed if the claims of the divisional application are brought from the specification of the parent application as against only the claims of the parent application. So, this gives us a clear interpretation of section 59 and section 16. And why should a divisional application be allowed to be based on the matter disclosed in the specification, while as against only restricting it to claims of the parent application? So this it has still to be seen. It is still to be seen how far the ESTRO order is implemented in letter and spirit by the patent office, and so we have to carry out. This has still to be seen. But in our opinion, in our experience with the patent office, the practice is divided. and you can still file a division application based on the matter which is disclosed in the specification, subject to the convincing the controller on the fact that that matter is directed to a distinct inventive concept. Now, so with this background and with this understanding, let us get back to the grounds we mentioned in our review petitions. So we argued that the method claimed in the divisional applications are directed to inventive concepts, which is different and distinct from the methods claimed in the divisional applications. To establish it, we provided a comprehensive chart comparing the granted claims of parent application with refused claims of divisional applications. Additionally, we pointed out that the subject matter of these applications relates to signal processing. And it is well known to the person skilled in the art that even a small change in the way of transmission of signal changes the characteristics of the output obtained. So further, the output from all the three methods claimed in the parent application and the subsequent divisional applications were graphically shown to strengthen our arguments. So we also indicated in our arguments that there are multiple solutions to one technical problem, and therefore different independent solutions must be accorded a separate protection. So this was the basis of our arguments. And gladly, the patent office found merits in our arguments and found our arguments to be persuasive and convincing, and acknowledged the presence of different inventive concepts in the parent application, with each of the different concepts being claimed in the further divisional applications. So the patent office observed that when parent application does have the claimed multiple, or it claims multiple inventions, but the actual extent or boundary or scope of these multiple inventions cannot be claimed in a single parent application, divisional application may be filed. The examiner further cited section 10.5 to admit that sometimes to reach a particular invention, several other inventions needs to be created or invented. So as long as these other inventions links to a particular problem solution, this problem solution can be claimed by application independently. But if the applicant tries to include scope of other linked inventions in the claims of same application, then objection regarding unity of invention may be invoked. So they had acknowledged that there could be a possibility where in the course of developing the invention, there could be multiple solutions which may have developed. And if it is disclosed in the specification, although the controller in this particular order did not specifically address whether the invention which was disclosed in the specification must be taken from the, filed with the divisional, or only the claims which was claimed in the parent application must be filed with the divisional. So that was not clarified. However, he agreed on our arguments that the invention does involve an inventive concept which is different from the one which was claimed in the parent application. And this is extremely important. I'll tell you why this particular order from the patent office was important. I'll tell you the reason. Because would remember I had mentioned that the title of all the three applications was similar, and therefore the scope of the claims were also similar. There were very less number of features which was dissimilar, and most of the features were similar. So there was difference of only one or two features, and based on that we could establish that it is directed to a different inventive concept. So that also suggests that even if there is a difference of one feature and it can be established that there is a different inventive concept, the patent office may also agree on the arguments and allow the divisional applications. So in this particular order, the controller also suggested that at any time before the grant of the patent, if applicant so desires on the ground that the claims of the complete specification relate to more than one invention, file a further application in respect of an invention disclosing the provisional or complete specification already filed in respect of the first mentioned application. So like I mentioned, this was important in these terms because the difference in the features is limited, were less. So the good news was the divisional applications were thus granted. So although I mentioned that the patent office did not discuss whether or not a divisional application may be filed for any matter disclosed in the specification, however, the order does give us an indication on the concept of inventive concept. It could be possible that could be only one different feature, which has the but if that one different feature has the potential to create a different inventive concept as against distinct features working together to direct the invention to a different concept, that would be sufficient. So even if that one feature which is different has a potential to create that different inventive concept. So again, coming to inventive concept, it's an abstract standard, but that since this is an abstract standard or an abstract concept, it opens up an avenue to convince the examiners at the Indian Patent Office that the application includes different inventive concepts, irrespective of the number of different features in the divisional claims vis-a-vis the claims of the parent application. So thus, it boils down to convincing the examiner at the time of examination when the applicant chooses to file a divisional application voluntarily, because the law is settled when it comes to filing a divisional application based on the objections raised in the examination report. But the practice is divided. The practice is different when it comes to filing a divisional application voluntarily. So this more or less sums up what I wanted to discuss on this issue.
Thank you, Mr. Mishra, for providing us such a useful insight. So I have noted that you have mentioned that the divisional application should be carved out from an earlier filed application, divisional application, I mean. So I would like to have Mr. Bansal's opinion on the question. Mr. Bansal, my question to you is, like in India, can we file a divisional application carved from an earlier filed divisional application?
Astha, I would just like to add a point before Chirag comes in. I just wanted to tell you that although the recent order of the Intellectual Property Appellate Court suggests that the divisional application must be filed or must be disclosed, not only disclosed in the parent application, but must be specifically claimed in the parent application.
Okay.
But as I suggested, this particular order is not implemented in letter and spirit by the patent office, and I also believe that the order has its limitations and the order is bad in law. So the chances are that we can still convince the examiner, even if the voluntary divisional application is based on or is at least disclosed in the specification of the parent application and it is directed to multiple inventions. So this is what I wanted to add.
Thank you, Mr. Mishra, for providing the clarification to our audience. So, Mr. Bansal, I repeat my question to you again. Please let us know, in India, can we file a divisional application carved from an earlier filed divisional application?
Asta, thank you for this question. As already discussed, section 16, which details about the divisional application by Mr. Mishra, I'm just again, briefing the section 16 in order to answer the question better. Section 16 of the Indian Patent Act, which details the divisional application, describes that a further application in respect of an application disclosed in the provisional or complete specification can be filed if the application or the specification contains more than one invention. Thus, by the reading of the section 16 of the Patents Act, it does not bar filing a divisional application based on a divisional application. However, based on numerous controllers orders, it is clear that a divisional application arising from a previously filed divisional application is not allowable in India, and it is a topic of debate because Act does not bar it and the practice is inconsistent with the reading of the Act. Means up to some extent, this debate is settled by the order of the IPAB in the case of the National Institute of Immunology versus the Assistant Controller of Patents and Design, and Milliken and Company versus the Union of India and others. In these cases, the Intellectual Property Appellate Board or the IPAB ruled that further divisional application is allowable because the controller in the first examination report of the further divisional application had himself raised the objection related to the lack of the unity of invention. So in this case, the IPAB established if in the divisional application controller has raised the objection related to the unity of the invention, and in order to remedy the objection raised by the controller, the applicant can file a divisional application. However, this order does not settle whether voluntary filing of a divisional application based on a divisional application is allowable or not. Recently, in the month of October 2020, the IPAB in the case of ESCO Corporation versus the Controller of Patents and Design passed a judgment. This judgment ruled that the filing of a divisional application arising out of a divisional application is allowable, provided that the claims of the divisional find its roots in the claims of the divisional application. As already mentioned by Mr. Mishra, also that it also must satisfy the other conditions. As, for example, the divisional of a divisional application, there must be a presence of multiplicity of inventions and pendency of the first divisional application. Thus, this order puts to rest a long-standing ambiguity, and up to some extent, it clarifies that divisional of a divisional is not invalid solely for the reason that it is carved from a previously filed divisional application. However, as already discussed by Mr. Mishra, this judgment is not very good in law because it is inconsistent with the reading of the law or the act.
Thank you, Mr. Bansal, for providing your opinion on the said topic. So further, I have one more question to you. So can we file a divisional application based on voluntary amended claims that are not taken on record by the controller of patents? So what is your opinion on this?
Once again, thank you, Ms. Asta, for this question. At first, I would like to brief about permissible amendments as already discussed by Mr. Mishra. Section 69 of the Patent Acts, and as per the Section 59, specification of claims can be amended only by way of explanation, correction, or disclaimer. Further, as per Section 59 of the Act, no amendment of a complete specification shall be allowed, the effect of which would be that any claim of the specification as amended would not fall wholly within the scope of a claim of the specification before the amendment. And in practice, the controllers usually raise objection to amendments made to the claims if amended claims fall outside the scope of the originally filed claims. But by going the reading of the act does not bar the Patent Act does not bar filing such claims as objected by the examiner as claims of the divisional application, provided that such claims satisfy the condition laid down in Section 16. However, in view of the recent ruling of the IPAB in the case of ESCO Corporation, it is difficult to answer this question, is in either in yes or no. Since the Act does not bar, we recommend filing such claims as claims of divisional and shall leave the allowability on examiner's judgment. And as Mr. Mishra said, we will attempt convincing the examiners regarding the divisional application at the time of the examination of the patent application.
Thank you, Mr. Bansal, for providing your inputs on my question. I would actually take a moment here and I would like to add on something, I would say my insights on the ESCON order which has been passed by IPAB. So I feel the order not only give guidance to the applicant and give more insight about filing of the divisional application, I believe that the board also provides guidance for examination of the divisional application. So I would like to put some points which I have found out while reading the order, and I would like to present it to you. So according to me, the order provides an insight of saying that the presence of different embodiments in the specification claimed as an independent of set of claims may not necessarily attract the lack of unity of invention. Actually, the board recommends the controller to provide an option of amending the claims related to plurality of invention instead of outright giving an objection on plurality of invention. So what does it mean? It means that controller can look to the other options of amending the claims by providing objection under the heading of clarity of conciseness or clarity claim definitiveness. So if the remedy can be provided to the applicant by providing him an option of amending claims under these headings, then it would save time and cost for the applicant in filing a divisional application, as the applicant would straight away amend the claims and can pursue his invention in one application. Further, I have noted that the order also provides a guidance to the controller saying that the group of the inventions which the controller thinks related to the distinct invention must be identified in a number of groups. Like group 1 relates to claim 1 to 20 relates to this. Then group 2 is claims 21 to 30 relates to particular category. In this way, it minimizes the chances of filing divisional to divisional applications and needless to say legal complications. In this way, the controller as well as the applicant knows which claim is considered as a distinct invention. The third point which I have noted is that here the board provides a suggestion to the controller to examine the divisional application and the parent application vis-a-vis. I mean, so that it also provides the opportunity to applicant to amend the claims in line with the parent application or to carve out the scope of the divisional application from the parent application, and it also helps in avoiding double patenting. So the examination of the divisional and parent application, I would say, has been suggested to the controller to have a vis-a-vis examination. Further, the objection on the unity of invention, which is raised in the first mentioned application, shall be allowed maybe in that case if it fulfills all other statutory requirements and only unity of objection is there. Then the controller should provide an opportunity to an applicant to amend the claims to remove any conflict if it fulfills all other requirements. Instead of applicant going and filing other divisional application and putting its time and efforts in the prosecution of the next divisional application. So these are the 4 insights I would say I have noted from the ISKCON order. And I would say this order is welcoming as it provides clear direction and path for evaluating divisional application status. So this was my add-on to what Mr. Bansal has explained it to us. And now I would like to move forward to Mr. Aryan. So Mr. Aryan, so my first question to you is, as a patent attorney, what are the difficulties you have faced while deciding whether the client should go for divisional or not? So I would like you to share your experience with our audience.
Thank you very much, Astha. And I thank Mr. Misra, Mr. Bansal for explaining the law and what are the divided practice with regard to divisional application. On this note, thank you for asking this question. Firstly, I would like to give the little background here with regard to continuation application in USPTO. Though Mr. Misra has explained in detail the difference between the continuation application and the divisional application, but for our audience, I again repeat some point here so that it will set the right perspective before I say out what are the difficulties as a patent attorney I face. So basically, the continuation application in US enables applicant to continue to argue with the USPTO for a broader or different scope of patent protection, using the second set of claims and generally file after a notice of allowance is issued. So this is the general practice. And it is also important that continuation application filing is very useful and powerful concept as it allows claiming a subject matter that is present as part of the specification but was not initially included in the claims. So with this background, now it will be easier for me to say out what difficulties I face or like me, other patent attorneys must be facing while deciding whether we should go for divisional application or not. On that note, generally I face 2 kinds of difficulties or encounters with 2 difficulties. First is, well, if you see the Patents Act, there is no provision for filing a continuation application, as Mr. Misra rightly explained this thing in his portion. And most of the time, we see the proposed claims for divisional application, which we receive from the applicant, it prima facie appears that of a continuation application. Like it's a broader in scope, slight change in the language of the claim. So in this case, if we file a divisional application, and then we certainly get objection of double patenting, and it becomes a little tricky to establish the different inventive concept of the divisional application, with respect to the parent application. So this is the, in general, the most of the time we face this difficulty, that the claims proposed by the applicant for filing a divisional application appears to be like similar in scope to that of the parent application. The second difficulty is, which is very like quite often we face, either there is a gap between communication between attorneys and the applicant or some other reason, but this is quite often we face this, that the client desires to file a further application, that is divisional application, after the patent application is granted. So technically it is not possible at this stage to file a divisional application. So I would say these two difficulty I generally encounter while deciding or dealing with any request for filing a divisional application.
Thank you, Mr. Aryan, and that was a very useful perspective, I would say. And the second point which you have mentioned seems to be really interesting. So in this scenario, what would be your best advice to safeguard the interest of applicant?
Oh, thank you. Thank you so much for bringing this point about the second point which I mentioned earlier. Like I said earlier, there is no provision for filing a continuation application, but the Patent Acts do recognize the right to file a patent of addition. So patent of addition is similar to continuation in part in US application in US. So if the applicant is desirous of filing a further application with a different scope, and we have lost the opportunity to file a divisional application, then we are left with no choice but to file a patent of addition with some design around the scope of the claims and amendments of the specification. So like, since we do not have now opportunity to file a divisional application because the time period in which we should have filed has been already lost. So now we are left with no choice but to file a patent of addition. But here, our role, because the drafting of claims is art, it's not like it's a science, also it is an art, because we have to design around the claims in such a way that the scope should not change much, but during examination it appears that there is a different scope. So we design around the claims, and then we ask the applicant or the inventor involved to do some improvement, and then we suggest to file a patent of addition.
Thank you, Mr. Aryan, for providing your opinion on this. So I would ask a moment here. Shall I, give a brief about patent of addition to our audience so that they will be well versed with the discussion we are already having right here? So
Sure.
Me. Okay.
Sure.
Thank you. So I would like to discuss about the patent of addition. I would like to give you an overview on patent of addition application. So patent of addition comes in picture when an invention, when you have an already filed application, now you come up with improved or modified invention. Then we sometimes we suggest to file a patent of addition if you have a modification or improvement in an already filed application. This application shall be filed at any time after filing the parent application or grant of the main patent application, but before the expiry of the main patent. There is a plus point in patent of addition that you don't need to pay a renewal fee for any patent of addition. However, you need to maintain your parent application by paying the renewal fee. There is one more point to notice, that patent of addition cannot merely be invalidated or revoked on the ground only that the invention does not contain inventive step in view of the parent application. However, the most important thing to remember is you should have a novelty in your patent of addition over your parent, but inventive step is not necessary. Further, as I mentioned in divisional application, cross-reference here is also plays an important role. You need to refer your parent application while submitting patent of addition application. And patent of addition works in the same similar fashion as of an independent application. It would have a new application number. It would require separate request for examination. It will be published ordinary after like 18 months. It will undergo separate examination. However, the claims like in divisional should not relate to a distinct invention. But whatever claims are there in patent of addition should have a single inventive concept which relates to the modification or improvement of already existing patent. Patent of addition will only be granted after the grant of the main patent, and however, it will expire along with your main patent. In case, unfortunately, your main patent is revoked, or there is some issue in your main patent, it has to be revoked, then your patent addition can work converted into an independent patent if you request to the controller. But you need to pay the renewal fees as you are doing in your patent application. One more thing to note, that the date of filing on the patent of addition will be the date on which the application for patent of addition has been filed. I mean, to be more precise, I would say date of filing shall be the date on which the patent of addition has been filed. So this was from my side on patent of addition. Now I will move again to Mr. Aryan, and I have one more question
I would like to
Mr. Aryan.
Before you ask another question to Mr. Aryan, I would just like to add, like what Mr. Aryan said, divisional application, both from the perspective of drafting and prosecution, is a strategy. Like Manish said, Mr. Aryan said, you have to prosecute it properly before the patent office if you want to even convert a division into patent of addition, because once a patent is refused or granted, you do not have an option to pursue a divisional application. You have to have a patent of addition to cover the subject matter. So if Manish could also elaborate a bit more on how to I have there was a case. I'll just share my experience with you. There was a divisional application which could not be filed before the parent application was disposed, and the client wanted to still pursue the set of claims. And we suggested that we can file a patent of addition. And but the parent application, or the claims of the parent application and the proposed divisional application was directed to a standard. So they were not willing to make any amendments to the claims, because patent of addition requires that the claims must be amended so that there is a novelty so that the novelty can be demonstrated with respect to the parent application. But they were not willing on amending the claims, because then that amendment may render those claims to be not reading onto the standard. So that was their requirement. So we suggested that we can file a patent of addition by adding few of the dependent claims, and those dependent claims must be then supported in the specification. And later, at the time of examination, we'll try and convince the controller, because the requirement for the patent of addition is satisfied, and therefore it is also, maybe we do not amend the independent claims, and we could convince the controller that these additions in the form of this novelty in the form of dependent claims must suffice the requirement of patent of addition, and still you get a coverage or get a protection for the divisional application. So now we can continue with your question to Manish. So that is what I wanted to add.
Thank you, Mr. Mishra. Thank you for sharing your experience with our audience. So, Mr. Aryan, I have a question for you. So you have brought in our audience attention that the patent of addition can also be can be treated as an alternative to the filing of divisional application. So could you please elaborate on the law points related to patent of addition?
Yeah, so you said that can the patent of addition be treated as an alternative to divisional application? I would say patent of addition is not an alternative to divisional application, but certainly we can say it is a remedial measure to the missed opportunity of divisional filing. Because since we do not have opportunity to file a divisional application, and this comes as a help for us to go for a patent of addition. So it is not alternative to divisional application, but it may be considered as a remedial measures. Now you ask further, I would like to briefly tell about the law point related to patent of addition. And Ms. Astha, you have explained in detail the law point related to patent of addition. Whatever you have said, I would add two scenarios which patent sets describes about patent of addition. Means in which two scenario the patent of addition can be granted. So if you'll see form 1, that is application for grant of patent, there is a when you will file an application, then there is a column itself from the beginning itself, whether this application is like general application or a patent of addition or a divisional application. There is a column. So the first scenario in section 54 of the patent set, it describes about that you can file from the beginning itself by ticking out the column of this divisional application. So this is the first scenario. Then there is a main invention, and then you are filing application for improvement over the main invention. So this is the first scenario. The second scenario will be like there are two separate independent patents. Okay, and the patentee happened to be in the first case is also patentee into the second patent, and the patentee in this case requests to the controller that I want patent of addition. So in that case, if he requests, the second patent will be revoked by the controller and be allowed as a patent of addition to the first patent, main patent. And also you have already in detail talked about like what will be the terms of patent, when patent of addition, and when the patent of addition should be filed. You have discussed, so I am skipping that part. So this is all about what you asked.
Thank you, Mr. Aryan. So this brings me to one more question. I mean, I would like to know, and even I think my audience will also would like to know, like how you decide that the patent of addition has the novelty and inventive step. What is the criteria you follow? I mean, if you can put some light on this question.
Yeah. So in your brief about patent of addition, you also touched on this, and I would like to start with case laws. In the case of Vishwanath Prasad Radheshyam versus Hindustan Metals, it was held that an improvement, like because patent of addition is invention over the improvement. So it was held that an improvement to be patentable, it should separately satisfy the test of invention or inventivity. Okay, so in this case, it was said that the improvement should be separately satisfying the whatever the test has been laid out for inventive step. But in addition to that, section 56 of the Patents Act, it says that while deciding inventive step, no regard should be given to main invention, but the improvement must be novel with respect to main invention. In summary, I can say that your improvement should be novel, inventive with respect to all other prior arts. But the question is whether the main invention can be cited as a prior art. But in the case deciding the controller is deciding the novelty of your improvement, in that case the main invention can be cited as prior art, but not for inventive step. So in brief, I would say the improvement should be novel or inventive with respect to all other prior arts, but while considering with its main invention, it should be novel. So because there should be some improvement. Yeah, so this is from my side with regard to this question.
So our audience should not be confused on this, because it is important to discuss patent of addition, because once you miss the opportunity to file the divisional application, you need to understand what is a patent of addition so that we can use it as a remedial measure. So that is also important.
Exactly. So thank you, Mr. Aryan. So this brings me to my last question. So with this backdrop, as you also mentioned earlier, could you please explain how would you strategize to file a patent addition if the applicant has missed the opportunity, as also mentioned by Mr. Mishra, to file a divisional application?
Yeah. So thank you. You asked this question. Since Mr. Mishra has explained his own experience with regard to how he, like for a case where he has to file a patent of addition because he has missed the opportunity to file a divisional application, and the applicant happened to be like very rigid in his practice with regard to or changing in like the scope of the claim, because the claims was related to standards, some standards. So like Mr. Mishra said, in this case, we also suggest to the applicant to make some improvement over main invention and amend the specification accordingly, because patent of addition is over the improvement, not on your exactly the same invention which you have filed in the main invention. So as a first strategy, we file the claim set of patent of addition which the applicant wanted to file with the divisional claims as if it is a placeholder claim. So like if the applicant wanted to file a divisional application and he missed the opportunity, as a first strategy, we file the patent of addition, though we have made some amendments in the specification and the claims, but we file the claims of the same claim set which the applicant wanted to file as a divisional application, but with addition to some dependent claims as a fallback option. So we file independent claims as if it is a placeholder claims right now, because we have to file and we have to like also take care of the interest of the applicant. So we file the divisional claims which the applicant wanted to file with the divisional application in the patent of addition itself. Now, since we have to prove the novelty of the patent of addition, the improvement application with respect to the main invention, But this is the onus on the examiner to find out or to cite main invention that the improvement invention is not novel over main invention. If the examiner cites the main invention that your improvement claim is not novel over the main invention, in that case, what we do is we merge, or we suggest to merge the dependent claims which we had deliberately included with regard to the improvement. So we merge that dependent claims in the independent claims to prove that the amended version is novel over the main invention now, and it separately now satisfy the requirement of inventive estate. So this is what we always suggest to our client in case the client has missed the opportunity to file the divisional application. And this way, like it kind of it provides a remedy to the lost opportunity of filing a divisional application.
Thank you, Mr. Aryan. I think the audience must have liked this answers of yours, because that is the most important aspect when what to do when we miss the deadline to file divisional application. So this brings to the end of our session. But before ending the session, I would request my fellow panelists to sum up their discussions and provide the insights to the audience. So I would start with Mr. Mishra. So can you please sum up your discussion?
Well, like I earlier said, the practice with regards to divisional application, particularly, my focus was voluntary filing of a divisional application. So particularly when you voluntarily file a divisional application, is not consistent across the patent offices in India. So an applicant may certainly file a voluntary divisional application as a strategy and wait until the application is picked up for examination, where the applicant will have the opportunity to explain to the examiner the reason the claims are directed to a different inventive concept, irrespective of the extent of similarity and dissimilarity of claims between the parent and divisional application. So my focus was voluntary filing of divisional applications in India, and that is the area where the practice is divided, and that is why we have titled the topic as divided and divisional. Especially it refers to voluntarily filing of divisional applications. So this is what I believe, and my suggestion for the applicants would be in terms of voluntary application, voluntary filing of divisional applications in India.
Thank you, Mr. Mishra. It was very useful. So I would proceed to Mr. Bansal. Would you please conclude your discussion and provide the conclusory statements to the audience?
I can't hear you, Mr. Bansal.
Thank you, Ms. Sharma. As we already discussed, filing divisional arising out of divisional and the judgment of the IPAB in the case of the ESCO Corporation. So it has been, established by the IPAB that divisional can be filed voluntarily, but based on claims already been filed with earlier divisional applications. So this is the note of the IPAB that yes, voluntarily filing of the divisional is allowed, but based on the claims which have already been disclosed or being claimed in the earlier divisional application. Further, concerning voluntary amendments not taken on record and filing divisional application based on such claims, we recommend filing such claims as claims of divisional application and leaving the allowability of such divisional application on examiner's judgment, as we already discussed in detail. Means this is my opinion regarding concerning voluntary amendments and filing such claims if not taken on record as a divisional application. We recommend filing such claims as divisional applications.
Thank you, Mr. Bansal. That was really useful. So I proceed to Mr. Aryan. Can you please sum up your discussion?
Yeah, thank you, Astha. So I would say this is the high time the government should, or the parliament should, bring amendment in our patent act and to allow the provision of continuation application, because for a applicant, it is a kind of negotiation with the patent office. What broadest set of claims they should have protection on. Like during the first prosecution of the application, if the claim is amended in such a way that it is narrower, so continuation application gives the opportunity to applicant at that latter stage of time that they can again bargain with the patent office with broader set of claims. So from the applicant point of view, this is the high time, and following the more mature patent jurisdiction like US, the Indian Patent Office or the Parliament, the authority should amend the Patent Act and bring the provision of the continuation application. That's all from my side.
Alternatively, I would also suggest if there is more clarity on filing of the voluntary divisional applications, and that should be based on the specification of the parent application. I think that would also, at least for now, would better things when it comes to filing of voluntary divisional applications.
I agree with you, Mr. Mishra. So this brings us to the end of our session, and I thank all my fellow panelists and the audience for being with us. And we are available for questions. You can shoot any questions to us, and I thank everyone once again.
Thank you.
Thank you.
Thank you.
Thank you so much.